So we have got 130.
Have been given the rights.
हाँ सर
Kindly check that. No, this is we have entered room number 2 actually. Automatically क्या? Actually यार ये automatically room number 2 में चले जा रहे हैं हमारे मेंबर साहब बोल रहे हैं automatically room number 2 में चले जा रहे हैं
allocate funds for process reengineering. Much has been talked about it in the past. This is the first time we are seeing a budgetary allocation. And what would this process reengineering enable? What should a common citizen be able to do after this process reengineering? They should be able to easily access all information relevant to their case, and not just the orders and the judgment. Whatever they have filed should also be available digitally. It should be well explained what are the next steps in the case and what usually happens in the case. There should be a capability for citizens, lawyers, police, witnesses, and other stakeholders to perform tasks digitally, whether it is submitting documents or fees, filing cases or FIRs. All of these should be enabled digitally. And the task should be easy to understand. There should not be a cognitive overload on the citizens. It should be very easy. And we are seeing the success of other platforms, right? Like UPI, like other e-commerce platforms. There's a lot of simplification that has happened. And it is not just a repetition or a replication of what has happened in paper-based tasks that need to be focused on. There should also be an option for citizens to know what are the alternate methods of resolution, the laws applicable to their situation, and what will happen to their data. And I'm so glad to see that a significant budgetary outlay has also been made to outreach. And this will help not just in for the judicial officers and the institutional users. It should also be the material and the resources that are generated for this should also be used for upgrading the knowledge of citizens on what are the options to them. This is what you can do on e-courts. This is what you can have, what you can access through the common citizen Seva Kendras. And the budgetary allocation for that is also very welcome. And I hope a very concerted effort is made to bridge the digital divide through this Seva Kendras and the outreach programs. People also need to be made aware of what happens when you come into a court process. That we have seen is a very significant barrier for people to say, I don't know what will happen after I file a case. Whether I should file a case or not itself is a decision made based on the knowledge that they have on, is it going to take 6 months or 2 months or three years? What is it? There needs to be clarity on that provided based on previous experience. And this is where a lot of the discussion that has happened, the points made on using AI for building tools that will enable citizens, enable judicial officers. Justice Mushtaq talked about motor vehicle accident claims, right? So how can AI help in courts across the country in managing a similar type of case better, right? This is where the budgetary allocation to the AI head is again very welcome. While a lot of the focus is on the hardware, and it is really necessary because courts should enable and facilitate the remote appearance of parties and witnesses and lawyers. They should, while you cannot do away with the court as a place, court as a physical location, technology help should be taken as much as possible for people to log in, view proceedings, participate in proceedings. There should also be ways in which the exit from the judicial process, whether it is through orders or judgments, are also facilitated through digital. It's already taken place. It needs to be more widespread. The digitally signed machine-readable orders that can facilitate not just subsequent appeals, but maybe enforcement by other bureaucracy officers and institutions. Two last points before I close. One is, sir, is that in all of these, in all of this exercise, we should be mindful that the citizens should be seen as participants in developing solutions and the adoption. In running, for example, in running Seva Kendras, Citizen Seva Kendras, can the help of local help organizations, NGOs, Advocates Association be taken in running these Seva Kendras? Can local Advocates Association help in developing solutions, technology solutions that meet their requirements. So it would be important that citizens and the local advocates be seen as participants in co-creating solutions for in the phase 3. Finally, it is also important that the eCourts phase 3, it has happened to a large extent. I think the dramatic change over the last 6-7 years since 2014, when the eCourts enabled at scale all the information, we hope that it will continue to a finer degree and easier access to ensure transparency in the functioning of the judicial system, to see how many cases have been disposed of, which courts are doing how, if not at a case level, at least at an aggregate, say, case type level, which is available through NJDG, and we hope it will continue and cover more and more courts across the country. Sir, with that, I close my remarks, and I'm thankful again to all of you for inviting me for this talk, sir.
Thank you, Mr. Surya Prakash. I will now move to our next speaker. The next panelist of the session is Mr. Abhilash Malhotra. He is the Joint Registrar Judicial, also serving as the Central Project Coordinator, High Court of Delhi. He has hands-on experience in the rollout of eCourt Phase 2 in Delhi High Court, which has been performing very well as part of the Phase 2. Over to you, Mr. Abhilash.
Good morning, all of you, and my humble greetings to the learned Secretary, sir, the Honorable Justice Chavan, sir, the members of the E-Committee, and the honorable dignitaries who are there in this webinar. I am so humbled that I've been given an opportunity to share my thoughts on the topic of virtual traffic code before this esteemed platform. Myself, Abhilash Malhotra, and I am an officer of the Higher Judicial Service. And I'm currently working as Central Project Coordinator, and I'm serving in High Court of Delhi. And my job is to primarily execute the eCourts project. The topic of traffic jurisdiction, and especially the virtual traffic court, is very emotive to me. When I joined service way back in the year 2009, I was given jurisdictions of some police stations along with the traffic court also. And at that time, there was no concept of the virtual traffic court. And while holding the court as a magistrate, I have seen people coming physically to court, jostling for the parking space in the parking lots, waiting outside the court, huge rush, and then queuing up for the disposal of their challans, then waiting for the courts to prepare the fine receipts. And at the end of the day, I felt even to pay a petty challan, the whole of the day was getting wasting, and the papers were also getting wasted. But thereafter, the concept of virtual traffic court was introduced by the Honorable E-Committee. Delhi launched the spot jurisdiction of virtual traffic court in July 2019, and the second version of the camera jurisdiction, camera captured violations, that is the notice branch challans, in May 2020. To sum up, so far, we have disposed of more than 27 lakh traffic challans online on the virtual traffic courts, and a fine of more than 242 crores have been already realized. Virtual traffic court functions on the platform of Section 208 of Motor Vehicles Act, which provides a mechanism to dispose of the traffic challans in summary manner. The data of challans, which is captured by the traffic police through the e-Challan app, which is developed by the NIC, is pushed from the server of traffic police to the servers of the virtual traffic courts, which is maintained by the Honorable E-Committee. From the servers of the virtual traffic court, the judges are able to see these challans in their login IDs. The judges apply their mind, they take cognizance of the offense. They propose the fine under 208 Motor Vehicle Act. and the violator gets a notification about the proposed fine through a SMS on their registered mobile phone. After getting this notification, now I'm sharing the screen. The violator visits our website, which is Virtual Traffic Court, and he is able to see this proposed fine. And the violator audible. So
Yes, you are. Yes, you
Yes.
are audible. Please
Yes.
carry on.
So the violator is able to make the payment of his traffic challans from the convenience and comfort of his home. He is not supposed to come to courtroom. He is not supposed to jostle for the parking space. He is not supposed now to wait outside the courtrooms for and waste man hours in getting his challan disposed of. All he needs to do, go to our website, pay your challan, take your fine receipt, and the challan is disposed of. And the other magical thing is that the data of disposal is shared with the RTO office, the traffic police automatically through the API, and their records are also updated. Now coming to the e-courts phase 3. E-courts phase 3 has assigned a sum of humongous 413 crores to develop virtual courts. That is 1150 number of virtual courts. In addition to it, the money has been sanctioned for cloud space, hardware, video conferencing, and e-filing. I take all of these as ingredients of virtual court because all of these electronic facilities are required to hold a virtual court. You need a robust e-filing platform for filing of documents before the virtual court. You need a robust cloud platform to host the virtual court application online. And the money which has been given for the additional hardware and for creation of virtual court is definitely going to give a huge impetus in creation of virtual courts throughout the country. And I'm happy to inform you that Honorable IT Committee, High Court of Delhi, has already issued directions in Delhi to create digital traffic courts for contested challans. These digital traffic courts for contested challans are going to create the semicircle into the complete circle. Right now, what happens, you can, if you want to pay your fine, you can pay it online on the virtual court website. But in case you want to contest that challan, you have to, your challan is marked to the physical regular court. You have to physically appear before the court for payment of that traffic challan. And again, that is a painful exercise coming to court, wastage of the manpower time for a petty challan. Now the digital traffic courts, any challan which is contested on our virtual traffic court portal will come to this digital traffic court. The violator will be notified about the date and time of hearing. A dedicated web link will be shared with the violator for the video conferencing. The violator can appear before the digital traffic court from the comfort of his home or his office. He can contest the challan. The Digital Traffic Court has the facility to record the evidence online as per the e-filing rules prevalent in Delhi as well as in the other states of the country. These were the model rules shared with us by and now implemented in Delhi. So the digital court can record the evidence also, and the digital court can dispose of that challan in summary manner also. For example, a violator has been challaned for a red light jump. So he can always show it before the court that I was giving way to the ambulance. Or he has been challaned for non-production of driving license. He can always file the documents before the court that, I was having driving license, but I was not able to produce it at the spot. And the court can dispose that challan in the summary manner through VC proceedings. And the facility to pay that challan online has been already provided to us by the Honorable Committee on a web portal called pay.ecourts.gov.in, where am I audible?
Yes, you are. Please carry on.
Okay. So the magic these courts are going to do, they are going to save huge manpower time. What Motor Vehicle Act of this country mandates that when a traffic violation occurs, the owner and the driver both are challaned together. And as per law, both of them are required to appear before the court. Now with the digital traffic courts, the driver is not supposed to get stuck in the city. He can do his operations. If he's traveling, for example, the offense is committed in Delhi and he's traveling to Bombay. So he can appear from Bombay to Delhi court through VC along with his lawyer, and the challan will be disposed of, fine paid online, and that's it. And the money which has been sanctioned by the central government for creation of this virtual courts, creation of the infrastructure, is going to go a long way in helping the judiciary in not only bringing the traffic jurisdiction online, but majority of the summary trial offenses, right? Traffic jurisdiction is only one spoke of the wheel. In Delhi, for example, we are already having 34 digital courts of check bounce cases, which is summary triable offense. These courts are also working in complete digital virtual manner. Recording evidences online. They are doing the summary proceedings online. Nobody is appearing physically before the court. And similarly, with this impetus of the budgetary sanction, more and more summary jurisdictions can be brought online so that the precious manpower time of the country can be saved and the litigants can be given the true access to justice at their home doorstep. So this is all from my side, and I congratulate the members of the Honorable E Committee in creating such a special project, delivering it for the country, especially the team which is headed by Mr. Ashish Siddhokar for creating this fantastic technology. And I'm confident that their team will keep on delivering such ambitious project for the country in future also. Thank you.
Thank you very much, Abhilash. We will now move to the next panelist, who is Joseph Pukat. He is a lawyer at Supreme Court and High Court of Delhi. He is also a senior partner at APJ SLG Law Group. He'll be speaking on impact of e-initiatives of the government under e-court project, challenges and solutions from a lawyer's perspective. Over to you, please.
Yeah. Thank you. And good afternoon to everybody. So I just want to first congratulate the E-Committee, on whose report I presume the entire foundation of budgetary outlay has been given. Now, and I should also thank you for inviting me for this discussion. Now, coming to the topic at hand, there are several challenges and solutions from a lawyer's perspective when you look at this, when I do read the E-Committee report. Firstly, when we do look at the E-Committee report, the two crucial factors which need to be looked at was this, that they were looking at inexpensive access to justice for the citizens to the deployment of technology. Now, very clearly, to achieve outcomes, to make justice system more equitable and ensuring access of justice to all, there has to be increased technology adoption by all stakeholders. So it cannot clearly be only that there is one stakeholder which is using technology. All other stakeholders in the system should have equal access to the justice mechanisms. Now, when you do understand access to justice from a perspective of the stakeholders, you are typically, people only talk in terms of the online legal services, your e-filings, the remote hearings, but there's far more greater things to it. I remember 15 or 20 years back when I used to head an online database in this country. And it was subsequently acquired. But what we did realize was that there is a significant amount of analytics which judgments and decisions of courts and more particularly the laws which provided. If this data analytics along with the court records are mapped, they would significantly identify patterns and trends. And these patterns and trends could help court administrations and legal professions make far more informed decisions on behalf of the clients. Now, the key issue is what I thought I should deliberate right now at this point is this, that while has been a significant outlay, and there's been a significant outlay in terms of on the budget, we need to ensure that all of this expenses which is being incurred by the government do not end up in additional shelfware. And if we are having the discussion 4 years later or 5 years later, we should all be happy to say that we have adopted the process which was adopted, or the technology which was implemented has gained quick and fast acceptance by all the stakeholders. How would we be able to ensure that? And I think we will have to essentially borrow from the way commercial institutions do work. That have we done adequate research on the UI and the UX to ensure that there is greater acceptance of the tool and the infrastructure, so that the end users, whether they are litigants, lawyers, and judges, are happy to use the system and happy to use the technology and the deploy. That essentially means that at the stage of the implementation, all stakeholders should be involved in the design of the systems. Surya, one of the did indicate that how consumers should be involved in this process. That is a very noble thing, because clearly they are some of the biggest. The consumers in this case, being the litigants, are people who are at the wrong end of the stick. They are invariably, many of them are forced to come to the courts, made to wait long delays. And when there is frustration at their end, you realize that there's something wrong with the system. And this is something which we need to essentially address. So can we bring in better design? And especially when you think in terms of technology, really understand that some of the best technology tools which are available, the multinationals, they have all come in with great amount of research, both on the design, in terms of the interplay, in terms of the user feedback. All of this has been considered. So can we make a change which is significant enough to make sure that there is significant adoption? I'm very happy, and I think very clearly one of the previous speakers, Abhilash Malhotra, did indicate that how the traffic system, how they have revolutionized that through use of technology. That is very clearly a commendable act, both with respect to the fact that the traffic challenge could be paid online, and clearly it declogs the system. Same thing with respect to the Negotiable Instrument Act. Very clearly, I was reading some statistics that nearly 25% cases which are clogging up with clogging up many of the lower courts, the lower criminal courts, are coming cases which arise out of check bouncing. These are aspects where technology could clearly declog the system. Similarly is the case relating to, for example, motor accident insurance. We could clearly declog the system by addressing it, because some states like Maharashtra have significant amount of cases which I was told it's about 20%, which are essentially clogging of the system. So if we can bring in technology in those specific areas, we would be able to get a greater performance out of the system, and whatever the investment which is being done by the government would be able to would achieve its final outcome of getting access to justice. And one more thing I should indicate that we are at this point of time, and we are in a position to lay the framework for a project which would stand the test of time. That essentially means that we probably need to bring in some sort of an ontology or a taxonomy system where all of this information could be secured and could be something which would be relied on by future generations. The tax which we would sit in today could be relied on in future generations, so that the same digital plumbing system which is currently present could be present and be used for all times to come. Can we ensure that? For that, can we get some of our smartest engineers in the IITs and the triple IITs to get involved in this process, and help in creating a digital infrastructure which would stand the test of time? This is probably one important aspect to be noted. And I would only request that, if in many of these cases, we have very smart lawyers, we have smart legal tech companies who have the ability to contribute. If we could release APIs on test case basis to them, they would be able to use and access the information, the data which is arising, and probably able to come out with better suggestions as to how the system could be better utilized. Because one thing is there that with a large outlay and with the 4 slides which I had earlier seen with respect to the specific training and the outreach programs which we are planning. Clearly, if these training and outreach programs are to be made successful, it would require the involvement of good technologists and young students, whether lawyers or from the engineering background, who could join and improve the entire process which is involved. I think these are some initial thoughts on this. I do not want to go longer than this, but I have indicated my views on how we could possibly see how the existing outlays which have been provided we could get the most out of this. With these short words, I would like to conclude, and thanking you all for giving me this opportunity to speak.
Thank you, Mr. Joseph, for your time and for the effort you've taken in joining us for this little talk. We'll now move to the next panelist. He is Mr. Chakit Swarup. He was formerly with the ICGS design team. He has now moved on, but he is a very well-versed person in that. He'll be talking about the seamless integration of ICGS and the ecosystem, the way forward. Over to you, Mr. Chakit Swarup.
Thank you, sir. I believe I'm audible.
Yes, you're audible. Please carry on.
Thank you, sir. A very good afternoon to honorable dignitaries and respected audience and renowned speakers. I'm really thankful to the Department of Justice that they provided me this opportunity and shared the views, especially Mr. Joseph and Surya Sahab. They have correctly said that the systems are made for the people. And luckily, I have been in Ministry of Home Affairs for 112 and CCTNS and other pillars of ICGS. And my earlier superiors, Joint Secretary Sahab, has once said that, hey, it is going to help the system, the people, but how it is going to help the people at the grassroots level, the consumer, the citizen of India. It is more important that they understand all the jargon of this new technology. It should help them. It should become a tool and not a luxury for the other stakeholders. It should help the people. So, sir, I would try to help and understand the people to the different pillars, how ICGS is working. I'm going to share my screen and put off my camera for the time being for better bandwidth. Is my screen visible, sir?
Yes, it is visible. Please carry on.
Thank you, sir. ICJS, or Interoperable Criminal Justice System. This is the ambitious project of Government of India to integrate the 5 important pillars of criminal justice system by use of information technology, so that information can flow among these different components of pillars seamlessly. This is an excellent example of e-governance towards social justice and speedy disposal of legal cases, so that information flows from police station, as I have listed here in the order, how the information is generated and flows to the different pillars. First of all, the police station CCTNS system, where the FIR is registered. Prior to this, I have been in 112 or ERSS system, where the citizens call the 112 number to call the police. Once police register the case in CCTNS system, this information should flow to the e-prosecution, and a PP, public prosecutor, and the officer allocates a prosecutor to the case. And the communication between the police and prosecution should be seamless in the digital way. The documents, the evidences, besides their physical presence, should be available to both the stakeholders on the fingertip. From the e-prosecution, the case goes to the e-courts, and the Judge Sahab can see the information on their terminal, which has been generated in the earlier 2 pillars. The e-courts is a hub for the entire criminal justice system, and they can communicate to e-prosecution, from the CCTNS, the e-prison, and the forensics, the last pillar. So all this digital information in the terms of whether we can see in the paper or on the screen, either way, it is as perfect as it should be. The digital way, when we transform the information, it becomes easier for the stakeholders to look at. Luckily, my mother has been public prosecutor, and I have been earlier, before being an engineer, in touch of my mother, and she has been describing in earlier days how it was difficult and time consuming just to carry the documents from one, say, for example, forensics to the prosecution, and from the police to the courts. So the objective of the entire exercise is to save the time among the processes, the time-consuming processes. And under the disguise of processes, the citizen should not be deprived of this facility. So they should be capable to use these processes, rather than they should be deprived of their time and their right to use these facilities. It also has the citizens to save their precious time in the criminal justice system to get the outcome quickly and to stop the wastage of time in line of traditional lengthy processes. Another objective is to keep the information handy for each stakeholder and make it easily available to all the stakeholders in its genuine form. Genuine form means that it should be clearly visible and not manipulated. And with authenticity of the information, like vital documents, evidences, and past witness statements. System also keeps a track of chain if adjournments the court along with the accountable party details to help the subsequent judicial officer. As in a famous movie, the Tariq pe Tariq, and citizens keep getting the next date because the other party is just under the disguise of process that I'm going to fetch this document or that document, that sort of thing. The judicial officer also knows that how many adjournments have been done earlier and which party is responsible for that. Suppose he has said "Mujhe bukhar ho gaya" or like something. So how many times they could make the same reason for presenting the reason. So other party can say, hey, this is on the screen that how many times it has happened and the past history. In the first phase of the project, it was envisaged that each pillar starts getting the information on individual platforms. And separately, all pillars were grown to the day that they start working on individual pillars. In the second phase, the objective was to avail the information from one platform to another. If some information has been generated in one pillar, it should be easily available to the another pillar on a fingertip. immediately in the real-time basis. The third phase, the most advanced phase, this is envisaged that information is entered only once, and its reusability can be ensured so that it helps to maintain the authenticity and quality of data, so that even if the wrong information has been entered earlier, now system provides an opportunity to rectify information subsequently in the earlier records. For example, the spelling of a person is wrongly entered in the FIR, and in the court case, it is different. So the information is flowing from FIR to prosecution and to the court case. And the marriage between the FIR number and the court case number is clearly mentioned, and the data is interchangeable and interoperable. That's the basic objective of ICJS. One marathon task for the phase 3 is to digitize more than 3,000 crore documents in the courts by digitally scanning and converting those papers into the digital form, all the old documents, and to keep it in a big data repository. Big data is the boon of the latest technology, where despite being a peta-size byte, which is 1,000 into 1,000 times of gigabytes. Sorry, sir. A repository petabytes.
Please carry on.
Okay, thanks, sir. The big data repository petabyte size is an enormous pile of data, and despite bringing the data from an entire country, still it can produce the data and access the data at a real time and a real fast speed. And references in the likewise cases as a reference can be presented and can be fetched from this big data repository. The provision of solar panels and e-Seva Kendras in court premises will further bolster the process and will serve as a subsequent infrastructure for the citizens. So basically, it's a journey, and we are providing a platform, an infrastructure. In the coming days, it will further evolve that how these facilities can be used. Right now, these are being made as a platform that, hey, at least we have the data. Now, how it can be used is being presented today, and for tomorrow, it will be presented in a far better way, and new systems and new processes will be available, and the system will evolve. So we are providing a platform right now that at least the basic things are provided, and that in future technology will evolve. Actually, it is safer to present the digital copies while securing the physical documents and forensic evidences at a safer place by interconnecting the e-forensic and e-courts. By connecting e-Trisham, high security witnesses can be presented by means of video conferencing as well, as sometimes the danger for the witness to present it. And the witness protection program, as in other countries are there, the witnesses are protected from because it's another danger to their lives sometimes. So our infrastructure provide that kind of security to the witnesses that they can be fearless in providing their information, and people want justice, but just if there's a danger to their lives, it's the duty of the system to protect them from that fear. So that video conferencing facility and the seamless thing provides to them. It becomes easier to communicate between the prosecution and police station to normalize and rectify the case before presenting to the court. For example, the public prosecutor may say to the police, hey, this is not in the right format, kindly normalize it. So they can be interchanging the documents internally at the real time while sitting at their respective places. Major points in e-courts, as Honorable Joint Secretary Saab has already presented. I would just take the basic points like digitization of the entire court records, which is scanning of the documents, and there's a transliteration and translation. Two processes are involved. One is reading the OCR and converting them into the text, and one is keeping in the digital form as it is, and can be presented in the paper form or could be translated into the text. ICT infrastructure, new set of courts, e-Seva Kendras, paperless courts, development of software applications. As Joseph Saab correctly said, that the software should be user-friendly, and the UI, their interface should be acceptable to all the stakeholders, to the officers, to the citizens, to the police. Sometimes, in a federal country, we have vernacular languages, and most of the technologies have been in English, but NIC and CDAC are working hard to convert this in our vernacular languages as well, and the seamless translation and interchanging between the two languages. But still, it remains at least available in the vernacular language as well as to be translated to English or Hindi language. Development of software applications, solar power facilities, so that it is always available and the power failure should not be a case, especially in the smaller cities. E-filing of cases, connectivity, which by the boon of 5G technology, it has become really seamless nowadays, and the speed is becoming day by day faster and affordable. So connectivity is another backbone of the entire system, and which is nowadays it is really has evolved to a real fast speed. Live streaming of proceedings.
Chakit, I'd just like to request you just to keep it short, please. We've already overshot the time.
Right. Artificial intelligence and blockchain. It is the latest technology and evolving, and it still requires, despite being so much advancement, it requires a human supervision over that. There are few challenges. Mainly challenges are large data and security, so that data should not be manipulated and should be available only to the authorized users, and it should be not be available without secured access. So access is one part, and NIC and CDAC are quite capable to provide that access management system. India is a federal country, as I earlier said, and different vernacular languages, which is a change to work in the vernacular language and to provide the translation to other languages. AI has become a boon in translation, but in its current form, human supervision and wisdom is required. In the zeal and excitement of getting the new technology, we have to be careful about its ambiguity, possible ambiguity, and both the parties should approve it before moving forward with the translated version with the artificial intelligence. It can provide a faster translation and transformation, but needs a human approval from both the sides. Thank you, Mr. Thank you. Thank you very much for providing me this opportunity. Thank you, sir.
Thank you, Mr. Swarup, for your insightful presentation. For the information of everybody, we'll be taking the questions at the end of the session, so please keep your questions ready. We'll now move on to the next speaker. The next panelist is Mr. Vivek Raghavan. He has a very dynamic portfolio. He was the Chief Project Manager and Biometric Architect with the Unique Identification Authority of India. And he is also very much involved in the technology platform for Aadhaar. He also served as CTO for Team Indus, India's entry to the Google Lunar X Prize. He'll be enlightening us about artificial intelligence, the imminent revolution in the Indian judicial system. Over to you, Mr. Raghavan.
Thank you, Secretary Sir. Thank you, Justice Chauhan. Thank you, Joint Secretary Sir. Thank you for the opportunity from the Department of Law and Justice to present at this place. I'm going to be talking about artificial intelligence and the role of artificial intelligence in the justice system. And I think that, as Prime Minister actually said today, I think that we have to see how artificial intelligence is a technology that needs to help the citizens in various ways. And I think that law and justice is also, therefore, a domain where I think artificial intelligence has an important role to play there. So therefore, I will move to my presentation, and then we'll go over some of the points, at least the ways in which the artificial intelligence can actually help in this. So. So can you see you can see my screen now? Yeah. So I think the first thing is, why should we use AI in the Indian justice system, right? And I think the primary view, at least at this stage, and I think that, things may change in the future, but is actually artificial intelligence should be used for improved efficiency in the judicial system. So therefore, its goal should be to assist stakeholders, including judges, lawyers, citizens, and automate simple and repeatable processes to reduce the backlog within the system. I think that should be the focus. And the goal is certainly not at this stage for artificial intelligence to write judgments or take judicial decisions. I think that is not, when we think AI, a lot of exciting things are happening. But at this stage, we can get a lot of value in the justice system to help in improving the efficiency of the system. Just 1 second, sorry. Sorry. So therefore, I'm then going to talk about some of these ways by which you can improve the efficiency of and so I'm going to talk about things of document translation. I'm going to talk about leveraging voice technologies. One of the new exciting things is leveraging large language models and how they can help to access information. I'll also talk about some of the other AI use cases, as well as at least the kinds of things that from an AI perspective we need to do. Yes? Can I move forward?
Yeah, please carry on. Please carry on.
Yes, okay. So the first thing is I wanted to talk about document translation. I think one of the things that actually can improve access to justice is by making judgments, submission, and all other legal documents accessible to every Indian. And I think this can be done by if you have the ability to translate various judgments and orders and other kinds of legal documents into various Indian languages. So we have actually made an early version. There is something known as Subhas, which is the Supreme Court Vidik Anuvad software, which is a translation tool which helps to convert documents from Supreme Court and High Courts and translate them into 12 Indian languages. And it is an open source framework, so therefore it is actually based on open source technology. Sorry, I'm getting some. Okay. And then among the things that, of course, it can actually do document translation with post-editing in Indian languages. It has the ability. Yes. As I was talking, we have the ability of doing document translation with post-editing. We have the ability to do document or digitization, that is OCR in many of the scripts, most of the scripts of India. We have the ability to actually have the support of legal glossaries so that you can actually create translations that are legally, which are in legal language. We have the ability to plug and play different kinds of translation models within there. So therefore, you can actually, as things improve, you can keep changing the translation models, and you have the ability to retain the original formatting of the document. This is something that is a capability that exists today to translate orders and judgments in various Indian languages. The next thing we see is, I think that beyond text is really, I think the revolution is the revolution of voice. And the goal is to make all legal information, documents, and proceedings accessible or even collected through the means of voice. And I think that is something which is so therefore, I think one of the things that is there is today we actually have quite accurate open source speech recognition software available in at least 13 Indian languages as part of the Bhashini project from MeitY. And I think the goal is that for all 22 languages, we will have speech recognition capabilities, official languages within this year. And having this kind of speech recognition and speech synthesis technology can actually be fine-tuned for the legal domain to actually both recognize and transcribe speech in any language. And I think there are many applications. Obviously, already we are talking about transcription of court proceedings, but you could even have evidence recording in court and online in various languages, recording of FIRs. just leveraging this voice modality, and I think and is actually can make a huge difference in the quality of information that is provided, that is available as part of the legal system. There has been in the last few months, and I think in the last few months, there has been a lot of excitement about these large language models. I think most people have heard about ChatGPT and various and its capabilities. And I think that these, I mean, and if you look at, no, I'm not talking specifically about ChatGPT, but you take about at the core of these technologies can actually be helped to create a new generation of legal tools that can equip every citizen to access justice efficiently and effectively. So I think one of the interesting ways is that, and this is just a small thing, which is this is not specifically from the law and justice space, but is the ability where we actually take you are able to create a voice bot where a citizen can basically ask questions in voice in their own language and get answers back in voice. Now this has got many, many different applications, and I just play a brief about a 1 minute clip on what.
मैं एक किसान हूँ और मैं एक घर बनाना चाहता हूँ। क्या कोई सरकारी योजना है जो मेरी मदद कर सके?
Jugalbandi is a voice-to-voice system that allows user to have conversation in Indian languages. Currently, Jugalbandi is deployed on WhatsApp and Telegram, but can be deployed on feature phones as well using IVRS.
आपके इनपुट के आधार पर निम्नलिखित योजनाएं आपके लिए प्रासंगिक लगती हैं। आप किसके बारे में अधिक जानना चाहेंगे? 1. प्रधानमंत्री आवास योजना ग्रामीण। 2. प्रधानमंत्री आवास योजना शहरी।
मुझे प्रधानमंत्री ग्रामीण आवास योजना के बारे में बताएंगे?
Behind the scenes, Bhashni language models are being used to convert user query from Indian language to English. Then OpenAI model is used to reason on an authoritative document. The response is then converted back into Indian language and provided to the user.
Sorry.
मैं एक किसान हूँ और मैं
Yeah, so I think the interesting thing is that usage of these kinds of, this is just an example of the kinds of things that can be done. There are actually many, many things that are going on in this space. And I think can revolutionize access to legal information and documents. And it is available through voice in English or voice in local or vernacular languages. And we can actually force and control these to look at the genuine information to make sure that things that are coming out of the system are actually from authoritative sources. And use cases of these kinds of things could be things like, citizen general legal aid, hand-holding the citizens through the court process. So when all of these things become conversational in their own language, the accessibility increases greatly. Things like judicial assistance, dispute resolution, and many, many more possibilities are coming through in systems like this. Interesting thing is that there's a whole bunch of actually tools that people are building right away today that are actually kind of looking at different ways in which this kind of thing. So there, for example, there is this ability to actually question on various government schemes. There's another one where you actually work on a judicial research assistance where you're looking at particular laws and acts and you're asking questions and you're getting answers from them. There are, contract drafting tools, all kinds of legal aid schemes discovery. So there's a whole bunch of different things that can be done, which actually increase access to justice through using these large language models. Of course, beyond that, there are many other use cases like automatic listing of cases, for example, judicial research tools, tools which help to assist in drafting of orders and judgments, automated scrutiny, verification and notification of defects in cases. All of these things are definitely very much capabilities that can come with the AI that exists today and actually can make a huge difference as far as the law and justice system is concerned. And I think that one of the things that, we have talked about AI, but what are the budgetary priorities, at least from a person who comes from an AI perspective? The first thing is this obviously digitization of the court records and the acts, and to basically enable large digital record repositories. That's one key thing, which is I think that digitization effort that the court is doing is important. But I think that prioritization of what needs to be digitized first, the most important things should be digitized first, so that we can start leveraging leveraging these things using the various other technologies we have is very important. The priority in which you do that. The second one is, I think, which also I think Joseph had earlier talked about, this APIs for court data. I think that there is basically the many of these this information that is there must be available as APIs to people who are working in the space, and that way you can actually much more dramatically increase the usage. I mean, UPI is a classic example, right? I mean, had we made one app and we said that this is the app that everybody is supposed to use, the usage would have been minimal. But then when we created the APIs and made the APIs available to the ecosystem, this system has exploded, and the system is being used so effectively by everyone in the country. So that's one of the things, that API access is one of the key things that we. Then, of course, the point is that there are solutions today, and there are leverage existing open source solutions to build applications in translation and transcription, and implementing these voice AI capabilities into every part of the judicial process, whether it is starting from the courts, or going to the evidence gathering, or including at the FIR level. And of course, finally, we should also create, and I believe that many of these new LLM-based technologies, especially in legal aid, etc., are going to come up in there. And finally, when you look at some new technology like AI, it is very important to have capacity building so that people understand how this technology can be used to the benefit of the system. So I think the courses and labs on legal AI capabilities in law schools and engineering schools are important, and also create labs or a national AI legal center to continuously develop new capabilities. And I think that's something that you should actually have something separate to that. So with that, I thank the ministry once again for giving me the opportunity to talk, and thank you. I don't know, somebody else. Sir, I'm completed my presentation. I mean, if Hello, are others able to hear? I am not able to hear anything.
No, I think the secretary is speaking, but they're on mute.
Okay.
I can
Or
see.
they're trying to
If you're
unmute. We'll
speaking,
just wait.
if someone is speaking, you may be on mute.
So Secretary Justice, if you're speaking, you're on mute. Just letting everyone know.
Can you hear me, Professor Bulia?
Yes, I can.
Yeah, please come forward with your question, please.
Yeah. So thanks a lot to the panelists for your remarks, especially our friend Vivek for a very crisp and precise sort of presentation of how AI can be used, and that's very well taken. But my question will jar a bit with the kind of remarks that have come so far. So please pardon me for that. What I feel sometimes is that AI seems to have become a buzzword. Number one, there are other technologies that are also highly relevant and that may not identify themselves as AI. But two, AI does have limitations, just like any other technology. For example, issues around explainability, biasness, fairness. So the question is, how do we address this while we are talking about AI in this context?
So I think, first of all, I agree with you, Professor Bole, exactly with your point that in the end, we are trying to solve the problems of the citizen. That has to be the primary focus. And AI is just a tool. Okay, it is a tool which there is some excitement about, but nevertheless, it is a tool. And unless the objective and intention of what you want to do with it is clear, I think then it becomes it becomes something that is just a tool, just a toy that people play with. Having said this, therefore, that is the first point. So it is a tool. The second point which I would like to make is that bias is a real thing, and bias and explainability is a real thing. But however, it is something that is actually manageable in the sense that you need to look at two important things. One is that when depending on the nature of the problem, you need to make sure that your data sets that you select, and a lot of the bias that is there in various kinds of algorithms, AI algorithms, are related to the data that was used to train the model. And the second thing is, of course, bias is something that needs to be continuously measured and understood. That is, and therefore you have to look at making sure that you are understanding the data which you have used to train your models and a better understanding of that, and a continuous measurement of whether bias is creeping into the systems. And these have to become, basic safeguards along which we have to, which have to be part of the system to make it effective. And I think that with great power comes great responsibility, and I think that certainly holds true in this case.
Thank you so much. We'll move to the next question. I think Deepika has her hand up. Can you ask your question, please, if you're able to hear me now?
Yes, sir. Sure. Thank you so much for this opportunity. Thank you for all the comments that all the speakers have made so far. It has been an enriching discussion and lots of points to take away. I had a quick comment followed by a small question to ask. This is regarding sequence of solutions. Now, given the scale and complexity of the project at hand, I believe identifying what are the solutions that need to be focused on at a foundational level is extremely important. Just to illustrate with an example, a few high courts across the country have prioritized digitization of legacy records, digitization even of ongoing records, and a few others have not. A few high courts have gone ahead and implemented e-filing, while a few of them have not. Given the difference that exists on ground, how do we then propose to move forward in a way that all the judiciaries across different jurisdictions are at an even level? And this becomes extremely important when we are talking about interoperability of different data systems. If these developments are happening in silos, then data management and data standardization will become a very complicated exercise down the road. So can I hear some thoughts on how the solutions are likely to be sequenced?
Am I allowed to address this question?
Yes, please go ahead.
Deepika ji, you have the very valid question that how these things will be handled. Number one, there have been some pilot projects over this and well tested the integration of different pillars. As you said that some parts have already done, some are as the budget is there for entire country. So answer your question is the complexity has been resolved and tested, and then it is proposed to the entire country. And the APIs, as Mr. Joseph and Raghavan Sahab has suggested, these are well-tested mechanism to float the data with accurately parameter by parameter from one pillar to another. It is not only the information, but the well-organized information divided among the parameters. These flow from one system to another.
If I may add, like your question basically pertained to the sequencing of solutions. Like, yes, some high courts were proactive and they have all done good amount of digitization. Some high courts were not that proactive. Now to bring all of them at one level, that's why this specific component of digitization has been incorporated in phase 3. Like earlier, some high courts who have gone ahead on digitization, they did based on their efforts and they could get fund from the respective state government. So to bring everybody at par, so we took stock, like the E-Committee, Honorable Chief Justice who heads this E-Committee, he had formed a small committee to assess what is the work done on digitization in respect of all high courts, and taking into account what each high court has done, we have worked out the target of digitization, which will now be across all high courts, that it is almost 3,108 crore pages. And that target has been distributed over 4 years. That is the duration of the project. So that will bring all at par once this project is rolled out. Thank you.
Sir, if you kindly permit, may I add one bullet point here?
Yes, please.
Sir, in digitization, what is important, as is already said by one of the panelists, is the target record which we want to digitize. Do we want to digitize each and every judicial record? Do we want to digitize all petty cases? Do we want to digitize the record which has already completed the statutory life of preservation? And the rules in this regard vary from high court to high court. So I think this is the area where we need to focus in the phase 3, that what needs to be digitized. And if we focus well at the core of the record which needs to be digitized, I think the results are going to be magnificent. Thank you.
See, there is clarity in this. Our phase 3, the broad implementation strategy is that the E-Committee, Supreme Court of India, would be giving broad policy guidelines, but the implementation is decentralized at the level of High Court. And standard SOPs have already been drawn for this digitization. Not all records would be digitized. That which is required, because digitization would be the foundation for the end objective of coming out with paperless codes. With NJDG and digitization of legacy and ongoing records and subsequent e-filing, that would enable the operation of paperless code, that which we are aiming for.
I can see one more hand up. I believe it's Madam Bharti Ali. Can you come forth with your question, please?
Thank you so much, sir. It has really been an enriching webinar since morning. I just will like to take off from on the last note on digitization of court records. My area of work is specifically children's rights, and you often come across the issue of protecting privacy and confidentiality of children as against judicial data transparency and accountability. And having looked at implementation of the POCSO Act in 3 courts using e-courts data, we realized that children and women as well are unable to access records in their own cases and therefore have to be dependent on others, which is something which may be looked at. It's important to protect privacy and confidentiality, but we've seen several countries finding a way out. And in this phase, I'm sure we can also find that way out. We can use strong non-identifying features such as pseudonyms, there's redaction. There are different ways of going about it. So I would request this to be considered. Instead of keeping records away in cases of violence against women and children, if we could find ways of protecting both privacy and confidentiality, as well as enhancing judicial data transparency. My other point is would be about having a clear process on accessing court documents, specifically for purposes of research. At the moment, I mean, as a researcher, one has to depend on the individual who may or may not permit access to certain court records. But the research is important, as all of us understand. And therefore, if we could have a clarity of process on access to judicial documents for purposes of research. And my last point, sir, would be on the fact that even today we are grappling with the situation of huge gap in data between what NCRB gives us and what comes out from the e-courts. So if we could work towards those areas as well. There are smaller, very small things that you don't find on e-courts, like, for instance, what is the rate of cognizance of a case by court. So, that's my final point. If we could look at the data fields which are so critical for us, that can help us work towards compliance on laws. I'll end on that note. Thank you so much.
I'll take the first question on the seeing the data of victims, like ma'am said. See, the Honorable CJI has now constituted a committee on privacy and data security. And that committee is doing a wonderful job. I think the report will be coming out very soon. Even Surya from Daksh, I believe, is part of that committee. So it has experts from all areas, and they're coming out with that report. And subsequently, after the report comes out, I think there'll be the guidelines which will be given by the Honorable CJI and the authorities concerned. And I think that area of your question will be taken care of. I think Surya will be able to add something to that, since he is also a member of that committee.
Thank you, ma'am. Yes, I agree with all that you said. These have been considered and factored in. We will see as we come closer to implementation, others will also know.
Do we have any other questions? Yeah, please come. Can we have your question, please? You are unmuted. This will be the last question for the session. After that, we'll wind up because of shortage of time. Yeah, please. Your question, please.
Thank you so much. I'm Sarika, and my greetings to all the dignitaries present here and all the participants. I think it was very heartening to see, the thoughts everyone echoed in terms of, creating a human-centered experience. Putting the human at the center or human experience at the center when we are revolutionizing the entire, access to justice. And I feel that the process reengineering is, also going to be one of the key levers, and it was very heartening to see a budget allocation around that as well. So what question that I have is, when we look at the entire digitization, how do we ensure that, this access is not just to tech savvy, people, but also to the layman who are not very digital savvy? And thus, the change that we are trying to bring in is more sustainable in nature. So thoughts around that would be very useful to hear.
Yeah. I can attempt something. I mean, I think one of the things, is that I think that we do believe, and I think that, and this is not just law and justice is just one area. I do believe that access to information in an understandable way through voice in the individual's own language, I think needs to be the goal. And I think that we are close to achieving that goal. And I think that that's something that in the next couple of years can happen. And therefore, if most people can access good information, right, in their own language, in a way that's understandable to them, right? And I think that if that happens, that's, I think, can really increase the access to justice. I just want to say that and I think these technologies are reaching a level where I think this should be possible. That's just, that's my comment as an outsider.
I would like to supplement Mr. Vivek Raghavan here.
Yeah.
In the phase 3 project, money also parked to strengthen the e-Seva Kendras. And I tell you, in my experience in the district judiciary and at the High Court, e-Seva Kendras are acting as a bridge between the poor and the technology. The poor who are not able to access technology, they visit our e-Seva Kendra. Our officials help them in links. Our officials help them in getting the digital orders and the judgments for them. We help them in creating their IDs. We help them in digitizing the files and lot many IT services we are offering. And I'm very confident that the funds we are going to get in the e-Court phase 3 project will strengthen and further increase the services which are offered by the e-Seva Kendra, and will also involve more stakeholders like legal service authorities or the paralegal volunteers to offer more and more commendable services. So I think e-Seva Kendra are going to be the pivotal point as the answer to your question, right?
Yeah.
Moreover, there is a MOU signed between the common service centers as well as the Department of Justice. So the services from e-Seva Kendras will also be connected to 4 lakh plus common service centers across the country.
Thank you so much.
I saw one more hand up. Otherwise, we can take one more question. I think.
One last question.
Yeah, this is Numesh. Can I speak?
Yeah, we saw there is a lady who's got her hand up. You can take your question. Yeah, Cordelia Kumar. Can we have your question, please? We saw your hand up. Yeah, please.
Yes.
Please go ahead.
Good afternoon to everyone. It's rather a suggestion than a question here. See, we develop the tools here. We develop fantastic tools, but how accessible is it for the litigants who or the advocates who live in the remote area where they are not technology savvy at all? And I would suggest we develop camps or engage techno legal advocates or who are techno savvy people to engage free camps here in the remote villages, so that the information, the tools that we develop here should be taught in the vernacular language, even to the common man, like the e-Court services app, which is accessible everywhere. But due to the lack of technology and lack of knowledge of technology, we are not able to, we still have people in the remote villages who, who needs access to these. And these can be done only through, training them on the technical side also with correct skill set and everything, more of a knowledge sharing on the knowledge sharing basis. So even a common man can access these e-code service systems, understand them and use them correctly. So it was just a suggestion. One thing is we can have free camps, even with the assistance of the E-Seva Kendra.
It was a very good suggestion. Even in phase 2, we got a suggestion for this from the Attorney General, because based on that, what we have done is we have now called for from the volunteering advocates. As you said, no, from each taluk and each district, we have now advocates who have volunteered, and around 4,000 advocate master trainers have been trained. So now they have become as a one-point contact. So in phase 3, they will be utilized so that these technological thing will go through them, because it is already in the module. We train them in the national level, and these advocates in the district and the taluk level, they take it in the vernacular language. So that TOT model is there in place, and it will be enhanced to much higher level. And one more, your concern of taking the digital divide, which is happening in the remote villages, for the litigants in public, if I want to join a video conferencing, I am very I don't tech savvy, means then now, as already said by our other e-committee member and DOJ, we have already entered into a MOU with the CSE center, which are available in the taluk center. So a day is not far. This person can step into the CSE in the taluk level and get what are all the initiatives which can be needed in the village level and in the taluk level. And in the district level, they can step into the every court complexes which will have the E-Seva Kendra. So this is the wide provisions which has been factored in for the phase 3, and we hope the phase 3 will bridge this digital divide.
Thank you very much. My sincere thanks to all the panel speakers, as well as all the stakeholders who took time off to attend this session. And it was really enriching talking to all of you, and we certainly hope that this flow of information and suggestions will continue in future also. Thank you very much once again.
Yeah, we are really thankful to all the panelists and all the participants for taking out their time and joining this session. Very good, valuable suggestions have come out. Definitely all these suggestions would be factored in while we are finalizing the action plan implementation strategy of E-Code phase 3. Thanks again. Thank you.
Thank you.
Thank you. Thank you so much.